not legal advice. This is a discussion on what may or may not be the case. I need to say that for the camera since I'm going to be recorded and in there. I'm like you, I don't want to be disbarred or struck off or anything like that. The Ruth Morrissey case. So let me just give you a little bit, because it's an important feature. So when Ruth Morrissey was 28 years of age in 2009, she went through a normal smear test with her GP, and that ended up in Quest Laboratory. It ended up in Grand Rapids, which was a lab that was not on the charter of labs that we're providing. But there had been a change in the US where they were obliging repeat smears on an annual basis, and they moved it out to every 3 years, and consequently there was capacity in labs. So they decided then to, when they were getting all of these tests from Ireland, that they distribute them to the labs that were not at capacity. But as it happens, Grand Rapids was fine, but they weren't on the charter and they had not been agreed with the HSE. So it's in the slide. So the 2009 went. In 2012, when she was 31, the test went, it was again a normal smear, 3 years later, went to Medlab here in Dublin, so it stayed in Ireland. In 2014, she went to her doctor with bleeding and was found to have quite serious cervical cancer. So as a matter of protocol and behind the scenes, in such cases there is a review. They go back over the review, but not necessarily tell the patient that your previous smears are being tested and being reviewed. So this audit was going on. She received treatment in 2014, then again in 2017 she had pain in her shoulder. It turned out that it's breast cancer, and the cancer is throughout her body, and so she was given a prognosis of 2 years. And was undergoing, she was operated on in 2018 and is still undergoing treatment. So as a normal protocol, there was a review of her smears, and two things occurred. The 2009 smear in the US was found to be incorrectly read, and that there were abnormalities that should have been picked up. The 2012 smear, the slide, was adjudicated again that it was incorrectly read. And the comment that was put on it was that the slide was scanty. Do you all know this? Okay, not. I had to look it up. But I gave a good guess. So the slide was scanty. Okay. And so in that, they fed that information back to her consultant. Her consultant was in possession of that knowledge in July 2016 when she came in for a review, and he forgot to tell her. Now, who knows how that consultation went? So we weren't in the room, we don't know. Perhaps it was really devastating and whatever, and he was dealing with what he was dealing with. So we're not going to consider that or adjudicate that. But she wasn't told, and it was only when the screening and the whole thing blew up in the media that she put a phone call in to say, am I one of those people by any chance? Was that me? And was told the news that yes, that is you. So in that, I suppose when we look at it, again, Kevin Cross goes back and he starts at negligence of Lister and says, you know, what is the standard of care? Was they negligent with regard to the 2009 smear, the 2012 one, and if they are negligent, what are the consequences that have flowed from that? Right? So. An interesting, well, it's not interesting, but while she was at the height of her treatment for cervical cancer in 2014, there was a routine smear test done, and that came back as negative. Right, so that gives you an insight into the precarious nature of reading slides. So even while she was known to have cervical cancer, she had a slide come back as negative. Okay. And I suppose there was an acknowledgement by Mr. Justice Cross on that there is, that it can be precarious. Okay, so as we go into what are the factors that had to be considered within the case are that what is the standard of care for a prudent medical scientist, what was the contract between the laboratory and the HSE. So the contract there was such that there is a difference in the UK, or a difference between in the USA and in Ireland. In the USA, the results are sent back to the practitioner, and the medical practitioner decides what's going to happen next. In Ireland, there is a follow-up or repeat, or it is the laboratory scientist that is to write those notes in. And consequently, there is that difference in that while it is allegedly not diagnostic, it is, because the decision made and put on those notes is a determining factor. There are the guidelines that are set by cervical check. We have the Bethesda system of adjudicating the accuracy of a slide, and that's where your scanty comes in. And then we have these two categories, and this is the area that this case hangs on, of the views of the slide, of the cells on the slide, as to be whether they are atypical, and you can go and read that yourself. That these are, and the terminology that was used in the case is that of, where they waste cells. So this is the borderline, cells. So in the system, I suppose we have the GP taking a sample, that getting to the lab, the adequacy of the slide for reading what was on the slide, and then whether at that point it should have been abandoned or not. If it was scanty, should it have been sent back for retesting and a new smear? And so that is a judgment call that you guys need to make and stick to, and not feel under pressure. That it is, while it was a peer review to look at a slide and adjudicate that 5,000 cells was sufficient, and there to reach that Bethesda standard, at the same time, do you have sufficient of that? The US specialists said there were 35,000 on their slide, and that was disputed, and in fact Mr. Justice Frost threw that out as being that he didn't agree with that. He didn't find it credible. And then also, what is the reviewing mechanism? So in the US, there is the screener and allegedly a full review by another party, and in Ireland it is the screener and then there's a machine review. So is that adequate? They're the sort of things, the questions that you need to look at and ask. The case came down to this area of whether the ASCUS and the AGUS, whether those slides or those cells, how they were considered and how they were adjudicated. So in his determination that it should be remembered that the vast majority of non-negative reporting of slides in the screening or involved reports involve either of these two categories. Accepting difficulties in defining what is or is not within those two categories, this must not lead us to the conclusion as advocated by the American Society of Cytopathology or its witnesses to that effect, that in most cases the misdescription of what are actually is not negligent. Right? So there is an American standard that says that, and it is purely for litigation purposes, and the Irish High Court now has ruled that this is not an acceptable standard in Ireland, and so that American Society of Cytopathology is not accepted in Ireland, and that this particular categories of cells, that if you adjudicate that to be negative as opposed to non-negative, that's okay. That is a reasonable decision for you to make, and that there couldn't be any negligence in that. So in the US, that is the protection for that particular category within the Bethesda determinations of what is on the slide or how the slide should be read. However, that has not been accepted. So he threw that out and said absolutely not. He's not accepting that as being a standard. It is purely for litigious purposes and to try and evade liability. So he came down to this Boland test, which is found in the Penny Palmer case. That is, what is to be seen on the slides? At the relevant time, could a screener exercising reasonably care have failed to see what was on the slide? Could a reasonably competent screener aware of of what a screener exercising reasonably fair will observe on the slide, could they have treated that as negative? So he's looking at what is on the slide, what can be seen on it. Could you fail to see what's on the slide? And if you can observe it, is it reasonable that you would observe and treat the slide as being negative? And then he goes further, arising from the Penny case, which is to say that when we look at what is on the slides, then on the balance of probability, and this is about weighing experts' opinions of what was on those slides. So the expert opinion in court was that yes, it was within that category, that particular category of borderline, perhaps waste cells, perhaps, and that's your area of expertise. But in order to say that this is negative, because negative means anything isn't going to happen for another 3 years, Cross's view is that you can't classify something as negative unless at that point you have absolute confidence. And what happens in him saying that is that up till now, plaintiff's role, put out the limbs of negligence, it is for the plaintiff to prove the limbs of negligence. When you say I have to have absolute confidence, then I am reversing the burden of proof. So if I am arrested for murder, I can sit and be silent. I don't have to, because the state has to prove that I was there, that I murdered this person. The same thing in civil law. Whoever is making the accusation has to produce all of the evidence. But if the evidence is they said that the slide was negative, then the burden suddenly flips over to the person who viewed that as negative to say, well, I had absolute confidence that that was negative, and now I have to prove why I had absolute confidence. So suddenly I am bearing the burden of proving why I was so absolutely. It's one thing being confident. Absolute confidence is an extremity that is beyond reasonable doubt. It's a criminal standard of proof that you have to be beyond reasonable doubt. Whereas in all civil law, the standard of proof is, the burden of proof is the balance of probabilities, which is you just have to be there 51%. You don't have to be 100% there. You have to be just 51% there. Then on the balance of probabilities, this is how it went down. In criminal, you have to be, beyond reasonable doubt. So if I'm buying a house, I might have doubts about, God, I hope it works out, I hope it's fine, but I know it's the right thing, and everything in me says it's the right thing, and I go ahead with it. And that's how they generally try to describe what is beyond reasonable doubt. Absolute confidence moves beyond that again. We're almost at 100% of absolute confidence that that is a negative slide. And I suppose that the consequence or the fear of that, or what arises out of that, is that he says, I hold that absolute confidence is the screener's practical duty in relation to their analysis of what is on the slide, and indeed to the adequacy of the sample, and that the legal issue is whether or not they carried out that duty in accordance with the Dunn principles. So before anything, before we get into whether it was negligent or, we go, if you adjudicated it as negative, the burden is flipped over for you to prove why, with absolute confidence, you were able to say that that was negative. And I defy anybody to do that. That maybe that's so straightforward, but I don't think so. It is too, so it's much easier to go, and it's safer, professionally safer to say, there's an anomaly there, that's non-negative, and put it off to review for somebody else then to make that. Or else there is a burden to look at what protocols can be in place then to support that. Does it take 2 people to sign off on absolute confidence? Do we need 2 people to do that? Do we, so how is the system of review done? Do we have a special category? Because there will be probably in a screening such as the cervical check, you're going to have far more negatives than you're going to have positives, because that's the whole purpose of screening. And the reason that it absolutely had to be appealed to the Supreme Court is if that's the case, then everybody's going to be repeat screened multiple times, because until they're sure to be sure to be sure. We've now had 5 in a row, January, February, March, April, May, and we're probably absolutely confident now. So it makes a nonsense, and it pulls the purpose out of any screening program, and it doesn't allow for that space, that wouldn't be the normal civil standard, which is on the balance of probabilities. Another scientist looking at this slide would have adjudicated that. That said, the slide of the 2012, so here's a piece of legalese for you. This is what he said about it. Okay? So a reasonably competent screener must have absolute confidence to describe a slide as negative. However, given the similarities between the cells in question and normal cells, I am not satisfied that the plaintiffs have established on the balance of probability that a reasonably competent screener could not have treated this slide as negative, and accordingly, the failure to determine that this slide contained abnormal cells was not negligent. So the 2012 slide was adjudicated not to be negligent, even applying the absolute confidence standard. So that's where he says, I don't care what all the fuss is about, because even applying that standard, I was able to say, a competent screener would have said the anomalies, it was too similar to normal cells to be adjudicated as such. So it is possible to come through it professionally unscathed, but the fear and the implications of that. Okay, so, and these are his motive words, and this is where we went, I suppose when he said, in other words, if there is room for doubt that a slide was normal and the screener ascribes a normal result to that slide, then the screener is in breach of the Dunn principles, as he has been guilty of such failure, that no professional screener of equally specialist or general status and skill would have been guilty if they'd acted with ordinary care. A screening program cannot operate safely if screeners are left to judge the slides and whether they are safe merely on the balance of probabilities. So in that statement, he is ruling out that standard, the normal civil standard of application, and elevating it to this beyond that of the burden of proof of criminal law, so that just can't happen. Okay. So we have an imposition of a standard that is beyond that of the burden. You have to have absolute certainty. You can't have any doubts whatsoever in order to adjudicate a slide to be negative. And in that is a chilling effect. There's no question that would have a chilling effect on the administration of any screening program. So looking at it, so what can be seen on each slide? Would you have reasonably failed to see it? Would you have treated what you saw as negative? And if you're answering, if there are any issues as to the adequacy of the slide, then it must be decided in the light of an absolute confidence standard. So I suppose fitness to practice implications. First of all, your own qualifications and the updating and making sure you're doing your CPD. And make sure your house is in order in the meantime. Anyway, from a general standard, that's good, prudent professional practice anyway. Looking at your induction, your training, the protocols in your lab, looking at how it's done. If you have doubts about it, if you think that it's not best practice, then you should be raising those and getting, having that said. And that may or may not be difficult or easy, but that you consider that. Look, the factors in this were the contract between the lab and the HSC or third party, looking at quality assurance protocols within, are they being adhered to? There was some discussion in some of the evidence in the Morrissey case that maybe some of the protocols were not being adhered to. Professional liability, well, if your employer is is liable, vicariously liable in law for the actions of it is the lawyer, the employer that is liable. Are you adhering to guidelines? Are you proving that? And I suppose documenting what you see. The reports, the review report, the audit reports were missing information, where they should have been filled in, there was no information filled in. And I suppose if that is your role, if that's what you do, make sure you're filling in reports, make sure you're doing things like that, and make sure there's insurance, professional indemnity insurance, that those elements, that your employer is either doing it or that there is cover there for that. And then I suppose the question would be, do you have the discretion to say no? Are you under pressure to rule on every slide, even if they are scanty, even if they are? You know, what are there cultural pressures going on that need to be considered? And that's it.